When I asked him about living with his mom and what it was like to be around the father, he began describing abuse, shaming, and emotional harm. And it was very hard to watch. He broke down in tears. When you're in court, the court record doesn't show those emotions unless we bring it out. So very carefully, I had to ask him directly questions like, here is how you win your custody case. If you're going through a custody or placement matter in Wisconsin, you might be asking yourself, how do I win my case? And the truth is that there really is no shortcut. But there are proven strategies and evidence that the court relies on, and of course factors that the judges weigh very heavily. And today, I'm going to walk you through a recent case we handled and what we did, what worked, and what ultimately helped our client win custody and placement of her child. The story will not only show you what works in court, but it's going to teach you exactly what you should be doing if you're fighting for custody or placement in Wisconsin. I'm Kyle Kaufman. I'm a family law attorney at HKK Law Offices. I've represented many parents in custody and placement battles across Wisconsin. These are often the most emotional and difficult cases that we see, but there are consistent principles that win cases. I want to give you some Wisconsin basics first, and I'm going to do that before I dive into the story of what we did in this case to win. So let's clear up a quick point. Custody and placement are not the exact same thing. Custody refers to who makes major decisions for the child, and we're talking about things like education, healthcare, and religious upbringing. Now, placement refers to the schedule. We're talking about when the child is physically with each parent, and the court decides both of these things based on the best interests of the child. That's the guiding principle under Wisconsin law. In determining what's in the child's best interest, a court can look at a number of factors that are enumerated in our state statutes. This can include the child's safety and well-being, what each parent's ability to support the child emotionally and physically is, and the history of each parent's relationship with the child. Other factors include evidence of abuse and neglect and substance abuse issues. And very importantly, the court will look at each parent's ability to cooperate with each other and communicate. Now, this is the lens that every judge uses, these factors that are enumerated. And I want to show you how that played out in a real case. Let's talk about building the evidence first. In this case, we had multiple witnesses, 5, and more than a dozen exhibits. It included hundreds of text messages and even an audio recording of a voicemail that the father left for our client. Now, the content of these messages was really shocking, derogatory, vile, and truly among the worst I've seen in family law. I thought it was important that the court heard those facts to understand the case, because that kind of evidence is critical. It showed to the court that this parent was not focused on the child's best interest, and instead, the parent making these statements and remarks was using intimidation and verbal abuse. It simply didn't care. Now, there was a very human moment in this case, and it came about from one of our witnesses, a 20-year-old young man. When I asked him about living with his mom and what it was like to be around the father for the minor child, he began describing abuse, shaming, and emotional harm. And it was very hard to watch and listen to. As he spoke, he broke down in tears. And when you're in court, the court record doesn't show those emotions unless we bring it out. So very carefully, I had to ask him directly questions like, are you crying? Is this upsetting to you? Is this difficult for you to talk about? Do these memories and stories put you in distress? Were you in distress at the time? And it was hard for him, but his courage was really something that was remarkable, and it made a huge impact. Afterward, when we released certain witnesses from their subpoenas, then they were welcome to sit in the courtroom to hear the rest of the evidence, and they could choose to go through the entire proceeding or not. For this particular witness and another young witness, adult, being able to watch the hearing afterward, in my opinion, gave them closure. They saw the truth come out, and they were able themselves to really face their abuser. Why does all of this matter? It matters because the court has certain rules it needs to follow. The statutes tell us what is important. And the court weighs not just these documents, it weighs the credible testimony of the parties. And when a young person like this speaks with that raw honesty and it aligns with also the evidence that we're showing, the court is really tuned into that. And that's why witnesses matter. Text messages and voicemails matter. Consistent themes matter. It's not just a he said, she said when we have other people and documentary evidence proving our case. So we brought in other corroborating witnesses. This included the father's recent ex-girlfriend who testified at the hearing. And she confirmed what we had suspected: drug use, drug abuse, unsafe behavior, and a dangerous home environment. We were able to pull out things like that his home was coated with marijuana resin. It had cobwebs all over and spiders and even mold-covered cat litter. Now that gave the judge really a vivid picture of what life looked like in that home for an 11-year-old boy. And it was very descriptive and helpful overall to giving factual information to the court. Let's talk about how judges decide cases. This is not a flip of the coin. It's not just how they feel when they wake up in the morning. They do evaluate what's going on in the case and certain themes, as I call them. And in this case, we really had three major themes. We focused on the child's safety, the child's physical health, and emotional well-being. We talked about drug abuse. And if you're in a custody case like this and you think about your case through those lenses, you want to ask yourself, can I show the court my child will be safe with me? And can I demonstrate stability, school routines, and healthcare with me? Can I prove and support that my child is emotionally in danger or physically in danger in the other parent's home? And vice versa, can I show that it's a healthy environment with me? When you're able to do that and balance that out, that helps to win your case. Now, in this particular case, in the end, we achieved really exactly what our client wanted and a little bit more. But that's because we put it to the test. We actually put the evidence out there and the facts. And she was awarded legal custody, primary placement. And when the judge announced it, she gasped and she tapped me and cried. And for her, this wasn't just a legal win. It was protection for her child. This was real life and it's very meaningful. When you're in your case in Wisconsin, these custody cases are tough. They require evidence, strategy, and courage. And I want to remind you that while every client and every law firm could do this, in this particular case, this client actually did do it. And we were the only law firm that did it with her. So if you focus on what's best for your child and you build your case around the right themes and present credible evidence and stand out and present your case, you can win. If you're facing one of these custody cases, I do not recommend that you go through it alone. You need help. And at HKK Law Offices, we've helped countless parents fight for custody and placement, and we do it the right way. We want to make sure that kids, their orders are serving their best interests. We're here to help you and your family. Call us today for a consultation, and don't forget, subscribe to this channel for more family law insights in Wisconsin. Thanks.